Good morning, everyone. Thank you for joining us here on a beautiful Tuesday morning in Harrisburg, Pennsylvania, to talk all about basics of the right to know law. I am Liz Wagenseller, Executive Director of the Office of Open Records, and we have a lot to cover today. My colleague Dylan will be helping cover the material. And I will be starting out, and feel free to interject questions during the presentation, but we will leave time at the end. And sometimes it's hard for us to see as all the questions fly in, but we will do our best and get to as many as we can. All right, here we go. Hold on, we got technical issues, so cue some music. Waiting until we can figure out what's going on. I know. Lots of time to memorize our new physical location. 555 Walnut. We used to be at 333 Market, so sometimes I forget it's all 335. It's the fives. 555 Walnut. It's okay. All right, here we go.
Sharon,
It has a very delayed response to my advancing, so let's see here.
It started being weird when I started recording it. It's testing it before I turned the recording on, and everything was fine. And then as soon as I turned the recording on, it started to be weird. Okay, sorry.
Okay, so we're going to talk about why we have this law, how submission of a request goes, all sorts of things. We're going to go through a lot of steps. And some of them we will have to kind of be brought on. We have more specific trainings and some of these specifically, but that's all we have. Can people hear me? All right,
Okay.
so Holly, others can hear me. All right. Thank you, guys.
Okay.
Not. Okay, so why do we have a right to know law? What is the reason? I know a lot of you probably wonder that. If you're an open records officer for your agency, it can seem very kind of micro type of activity, but looking at the big picture, why do we have a right to know law? The idea is the public has a right to public records, and being able to see what is going on in an agency, to see how decisions are being made, what factors are being considered, is important, a way to hold agencies accountable for their decisions. If everything can be done behind closed doors with no one ever peeking in, some bad actors may have free rein to act badly. And so it is a way for people in democracy, in our democracy, to understand everything that's going on in the world of their local school district or their municipality or the state Department of Health at all levels of Pennsylvania government. We'll get to appeals soon, later on, Carol. So what are the basics of the right to know law? How does it work in terms of the steps that are possible? There are three stages that are potential stages in a right to know law request. First one is a simple request to the agency. You fill out a form for free and say, I would like to have these records. It's given to the agency. Then the agency responds, either granting access to the records or denies, saying you may not have access to these records. Overwhelmingly, over 95% of the time, that is where the journey ends in that request. Less than 5% of the time, when the requester is denied access to the records, they appeal to our office, the Office of Open Records. Again, it's a simple form they fill out for free, saying I'd like to appeal this decision, and then we have a brief time, 30 days, for the agency to defend their decision to our attorneys as to why they did not grant access to the records. And then we either uphold the denial or overturn the denial. So that decision is a legally binding decision. And overwhelmingly, 95% of the time, after the appeal, it ends there. Less than 5% of the time, our office's decision is then appealed to the courts. So that is an overview of the overall process for the right to know. And most of the time, I bet there are many of you who've never dealt with an appeal for our office because it's not often that things are appealed. Some of you maybe have someone who appeals a lot to our office, but that is kind of the general process. Now, in terms of what has been going on in the right to know law, I bet many of you have felt an increase. And though no one tracks the number of requests that are done throughout a year, we do track the number of appeals and believe that that mirrors what is going on in the request. And so you can see that we were kind of hovering around 3,000 for a while, a bit of an uptick last 2024, then boom. 2025, we barely almost reached 4,000 appeals. A huge increase, and we are seeing that if projections for this year hold, we will break that record easily. And so that is something that a lot of people are dealing with. And we looked a little closer because the beginning of 2025 was fairly normal. And we looked, and it was kind of, if you compare the last 7 months to the previous 7 months, the year before, that is where we've seen a huge increase. We've had a 63% increase in the last 7 months in appeals, a huge amount of increase of records. And one of the reasons that is happening is because of AI, to be honest. There's a lot more people who understand and utilize the appeal process because AI is telling them all about it. We'll get to AI in a little bit, but that is kind of the world that we're seeing. I imagine some of you may be seeing that as well. And that is something that we're trying to grapple with, just as the whole world is trying to deal with grappling with the AI in so many facets of life. It is something that we are also trying to deal with. Now I'm going to turn over to Dylan, who's going to talk about the process.
Sure. So here in a moment here, we're going to talk a little bit about what the requirements are for an agency to do when they have received a request. And so to begin with, this is all down to things like, the appointment of the open records officer, the processing and logging of the request and things like that. And these are just sort of the general things that any agency is going to want to do to ensure that they are complying with the law. So to begin with, agency must appoint an open records officer. That's the person who sort of serves as the initial point of contact for the requests. They can promulgate regulations and policies necessary to implement the law. And there are some limitations on that as well. And also the agencies may create your own request form, but you also must accept the uniform request form developed by the OOR. So if you receive that, in the mail or email or something like that. So upon receipt of the request, the open records officer needs to sort of note the date that the request was received by them, because the business day deadline is calculated based on when they receive it. And then you have 5 business days to respond to the initial request. So, and that can be the extension or the final response, but that 5 business day window is what you want to calculate right away. So within that 5 business days, an agency can grant the request. They can also deny or partially deny the request. And they can also invoke a 30 calendar day extension, which gets added to the end of that 5 business day period. And yes, for Pam, the 5 business day starts the day after the request is received. Yep. So for invoking the 30-day extension, generally you need to notify the requester in writing within the initial 5 business day window. And then you will also want to provide them with a reason for the extension pursuant to section 902, the date that you expect to respond, and estimates of costs. So that initial 30-day extension, the agency can invoke that unilaterally, but anything beyond that, the requester would need to agree to. And that you would want to have that in writing. So for Saris, what constitutes a business day? So this is based on your agency's business days, that initial 5 business day response window for small municipalities and things like that, that may be less than 5 days a week, or you may have different holidays in the state. The specifics of that can get into the weeds a little bit, but that is generally that it'll be based on your agency's business days. So it is important to keep these deadlines in mind because the consequences of a deemed denial, which is the term of art for failing to respond in a timely manner, can be pretty significant. You can lose the right to protest the release of sensitive documents. Courts can issue fines for failure to comply. There can be legal costs associated with that. And of course, there's problems of, general sense of opaqueness or suspicions, and requesters may choose to file more requests if their requests are being deemed denied and things like that. So it's important to stay on top of these deadlines and keep aware because the requester does have the right to file an appeal as soon as the deadline expires and the request is ultimately deemed denied. We also have a question about requests being caught in spam filters and things like that. I just wanted to note that, it is based on when the Open Records Officer receives the request. The specifics of what constitutes receipt can unfortunately be a little of a complicated issue that can come into play. That sometimes technical problems can cause issues with that, but I can't be too definitive about that right now. So briefly on prohibitions about agency policies. Agencies are not permitted to limit the number of records which can be requested or made available. You cannot put a cap on the amount of things that can be requested. And you also cannot require the disclosure of the purpose or motive in requesting access to records. So under the right to know law, the question is whether or not the record is public, not whether or not the person who is seeking it is entitled to it, if that makes sense. So you cannot require them to disclose why they are seeking what they are seeking. So now I will move on a little bit here to process of responding to a request. And we have a question about registering a replacement Open Records Officer really quick. If you go to our website, under the Right to Know Law tab, and then go to the search, the Find Agency Open Records Officer page, there's information about registering at the bottom. We can maybe provide that link later, and I think we may even mention it later. But so I'll continue here real quick. There are a couple things that are not required of an agency in terms of responding to a request. So you are not required to create a record that does not exist. This can include something, that may be planned to be created in the future. So, this, even if you're going to have something created in a few months, you're not required to create a record to respond to a request. You're not required to answer questions. Requests have to seek records, not ask questions. You are not required to provide legal research on behalf of the requester. And you are also not required to provide an electronic copy of a record when only a hard copy exists. So when you do receive a request, there's a sort of chain of logic that you can follow, some key questions to determine whether or not there is something that you ultimately need to provide. So first, the question can be, does the record exist? Is the item that's being sought by the requester a record that you have in your possession of in the possession of a third party? Then you need to determine, is it a record of the agency? Does it document a transaction or activity of the agency? Does it pertain to agency business and therefore constitute a record for the purposes of the Right to Know Law? And then finally, the question can be, is it a public record? And that will be, is it outside of the exemption categories? Is it not confidential? And if you sort of follow that chain down and you say yes to all of those questions, then you have something that may need to be provided in response to a request. So first off, does the record exist? The open records officer must be able to demonstrate that you made a good faith effort to be able to locate records. And this can involve, reaching out to potential custodians of records to obtain responsive records. So that can include contractors and some third parties in some cases, as well as, your own employees or whomever. And courts have sanctioned agencies or can sanction agencies that are found to make a bad faith search for records, and there have been sort of fees associated with that in the past, or fines, I should say. So I have a question about using the standard form. So I think we have mentioned this here, or we will mention it perhaps, but the agencies can have a policy to require the use of the standard form. If you don't have a policy like that, you may need to accept requests that don't use the form. So the 30-day extension, we had a question about that. When does the 30-day extension start? The 30-day extension, as long as it is timely invoked within the initial 5 business days, begins after the 5 business days expire. So it doesn't matter if you invoke it on day 1 of your 5 business day response window or day 4. The total response period will be the same. So 5 business days plus 30 calendar days. So I am going to move on here real quick. We will try to get some more questions later. And I think, like we said at the top, if I'm not able to get to your question during the course of the presentation, we'll take some extra questions at the end, and we'll also have our contact info there. So I'm going to try to keep it moving, and I apologize if I'm not able to get to everybody. So returning to what we were talking about, is it a record of the agency? So in order for something to be a record for the purposes of the Act, it must document a transaction or activity of an agency created, received, or retained in connection with a transaction, business, or activity of an agency. So, even if I'm doing it on my work email, if I'm just sending my colleagues a note saying, where do we want to go for lunch or something like that, that may not constitute something pertaining to a transaction or activity of an agency. So it may not be a record, even if I created it on my agency email account. So something to keep in mind here is that records can take many shapes. Whether or not something constitutes a record is not about what format it exists in or what account it's associated with. So things like, invoices or financial records are pretty straightforward, but so can things like social media posts, text messages, emails on personal accounts, YouTube videos, recordings of video and audio, all sorts of things can ultimately constitute records. So that is something to keep in mind when you're creating communications. So this is a music venue in Colorado that's run by the city of Denver, although it's not located in the city of Denver, it's run by the city of Denver. And there was an incident here a couple of years ago where there was a hailstorm that was, a pretty significant event. And there were some records that were created by some of the officials in that process that were ultimately retrieved under Colorado's public records laws, which are, of course, different than ours, but just in general, and there were some situations where they may have not wanted to have created certain records that were ultimately produced. So this is just an example to sort of keep in mind, agency records can exist in all sorts of situations, and that's something to be mindful of, both when you're processing requests and when you're responding to requests. So I have a question about counting holidays with respect to deadlines. So the initial 5 business day window is 5 business days. So if a holiday comes in there, that can, not constitute a business day if your agency is closed for that day. And then the beginning of the timer is only based on when that request is received. So if, for example, if a request is sent on a Saturday, I may not receive it until Monday. And that can also come into play with holidays and other calculations there. So finally, the last item is it a public record? So state or federal laws obviously can prohibit the release of certain information. Common ones here, HIPAA and FERPA, also things like tax codes and stuff like that. There are also exemption categories in the right to know law that can allow agencies to withhold records, although they don't necessarily prohibit the release of those records. And those are found in section 708B of the right to know law, those exemption categories that allow agencies to withhold records. So those are just some general items, obviously other laws are an important consideration, things like tax laws and stuff like that. So a little bit of information, what sort of things are almost always public? So financial records are almost always public. Generally speaking, of course, the public has an interest in how agencies are spending their money. So financial records are generally public. And then also aggregated data. So lots of things, that could be sensitive personal info. Sometimes those can ultimately be available in the aggregated form. So aggregated data is generally public. In terms of things that are often withheld, these are some common reasons. Personal identifying information, that's something that's very commonly withheld or redacted. That can obviously lots of sensitive information like social security numbers and things like that. Birthdays can sometimes be redacted. Insufficiently specific requests, this is a common thing, and I'll talk a little bit more about that a little bit later. Internal pre-decisional deliberation. This is a common exemption that we see. And again, that is internal, specifically internal deliberation. Records protected by attorney-client privilege, records that don't exist, and also records that don't reflect agency business. So those are some pretty common reasons why a record may be withheld. So I'll talk a little bit about the question of specificity. Is a request sufficiently specific? So this is a complex and often subjective question, and it's a bit of a difficult one to get into too much detail. And in fact, we have a worksheet on our FAQ, and in 2024 had an entire webinar devoted just to this topic. But the courts have provided a 3-part test to consider when you are determining if a request is sufficiently specific, dealing with, does it define a subject matter? Does it define the scope of records? And does it define time frame? Now, inclusion of all 3 parts does not guarantee that a request is sufficiently specific, and excluding one or more does not guarantee that it is insufficiently specific. So it's a complicated issue. We have in our database a huge number of decisions that have dealt with this, and like I said, and we've had a worksheet and previous trainings on this topic. To determine whether or not something is sufficiently specific. So it's a complicated issue, but this is just a brief overview of some of the criteria to keep in mind when you're trying to determine whether or not a request is sufficiently specific. So redactions. So when you are providing a record, you may need to redact things, but if a sheet or an item contains information that is public, but also information that's not public, the requirement will generally be to redact the sensitive information and provide the public information. So generally speaking, an agency is not able to assess fees to electronically redact records, which is the most common way that will be done. Nowadays, in particular, lots of agencies have access to software like Adobe or something like that that allows secure electronic redaction. In the event that you're not able to do that, you may be able to assess a fee to print and manually redact records. But that is becoming less and less common as more agencies have access to software tools, but that is something that can come up. So I'll talk here a little bit about some payment issues. So one thing is that an agency is only required to provide a record in the medium in which it exists. So if a record only exists in physical form, then the agency is only required to provide it in physical form, and they would generally be able to assess a fee for that. So charges for photocopying or storage devices, so if you're providing something on a disk or a thumb drive, are relatively common. Charges for redactions or specialized software, things like that are relatively rare. If you are going to be assessing a fee, you generally want to contact the requester with an estimate before the work begins. You may require prepayment if fees are expected to exceed $100. And then sometimes you can then settle up at the end after if the amount is different. And you can deny for non-payment for prior requests. So if a person has requested records, they've been provided, a fee has been assessed, but then ultimately they didn't come in or whatever the case may be, you may then be able to deny future requests on the basis of that outstanding balance. So that is something that can come up. And again, we also have had quite a lot of determinations dealing with that topic as well. So, okay, so if you are going to be denying a request, there's some things that you want to include on your letter responding to that. Of course, the description of the records that are requested, the legal and factual grounds for the denial, why isn't it public or why doesn't it exist or whatever the case may be. And then you'll also want to include, name, title, contact info for the open records officer. It's also important to include the date that the response is being sent on there. Obviously, date calculations for appeals can be important, and you'll want to include information on the procedure for filing an appeal. So, and that can include, if an appeal, will go to the Office of Open Records or sometimes to another agency. So now I'm going to talk a little bit about the appeal process. And I'm going to begin with, this is new, relatively new information. We posted an alert about this a little while back. This is going to come into effect next week. Beginning on April 20th, the OOR will no longer accept appeals via email. So if a person wants to file an appeal electronically with us, that will need to be submitted through our online appeal portal form, which can be found on our public website. So appeals, other documents sent to the Office of Open Records, except for in-camera records, will not be docketed or added to existing appeals. So with the exception of in-camera submissions, everything will have to go through the appeal portal. Requesters and people are also still able to make filings to our office via US mail. So that is still the sort of the alternative option to the appeal portal. But for anything that's being done online, we are no longer going to be accepting those via email. Those will need to be done via the portal. So this is just a quick little screenshot of what the appeal form looks like. It asks for all of the same information and everything like that the other appeal form uses, but it just goes straight into our database. So that can be done from the website for anyone who is looking to submit an appeal to our office. And it will, include all of the information that our office needs, and it'll give, it gives requesters a place to upload documents and everything like that. So complete appeal filing to the OOR includes the original request that was submitted, the response from the agency, any response from the agency that may include things like an extension, and also the requester statement about why they believe the records are public, why they believe the agency has erred in their decision, things like that. So those are the sort of the basic things that will generally need to be included. So an appeal to our office has to be made within 15 business days of the date of the mailing date of the denial. And I know we had some discussion about business days earlier. For what it's worth, this 15 business days is based on our office's business days, which are the state's business days, generally. So those can be appealed within 15 business days. They can appeal redactions, or they can also dispute fees. So this, requesters can dispute different aspects of an agency response in this process. Requesters are not required to present evidence or argument after filing the appeal. So the burden is on the agency to show why the records are being withheld or why they don't exist, information about the search. But the, they're not, the requester can choose to present argument or information that they believe is relevant, but they're not required to. The burden is on the agency. And then, so our office has 30 calendar days by default to issue the final determination from the date that the appeals officer receives that. So so we have a question here. I'll read it here. If the request is a simple question such as who won a particular bid, how should these be handled? So we can't advise you on how to respond to particular requests. I can't, one thing that I can say is that even if you believe that a request doesn't fully comply with the act, and I'm not saying the one that you're referring to doesn't. Obviously, I can't comment on that, but you wouldn't necessarily be prohibited from providing some information. But unfortunately, we can't talk too much about specific issues. So agency notifications of an appeal. So when our office receives an appeal and it is assigned to an attorney, you will get automatic notification from our appeal system with a login, and you'll be able to see all of the documents on there that include what the next steps are in the process, things like that. And then you'll want to contact your solicitor in most cases. You know, is it ultimately a legal matter? There are deadlines associated. There can be consequences associated with, you know, failure to fully participate. So it's important, you know, to get your solicitor involved. Our office's final determinations are legally binding final orders. So our office can order, you know, the production of additional records, things like that. They are issued within 30 days of the date that the appeals officer receives an appeal, unless the parties agree to additional extensions. And they are also, all of our final determinations are available for review. So if you have access to a service like Lexis or Westlaw, they are on there. But our office also has a searchable system on our website that you know, members of the public agencies can use to review prior case law. And that can be searched by exemption categories and things like that, as well as keywords. And then, so briefly here, there is another sort of option within the appeal process for mediation. So this is essentially an alternative option where instead of the traditional adversarial quasi-judicial process, the parties can sort of enter essentially a confidential conversation with a mediator from our office, who would be one of the appeals officers here, in order to essentially come to an agreement about the best way to proceed with whatever the dispute is on the records issue. So that is, and of course, people can back out of that if they want to and revert to the regular process. But that mediation is just sort of an alternative that you may want to consider. And, you know, it can be suggested to requesters and agencies alike. So last thing that I will talk about here before I hand things back off to Liz is briefly the judicial review. So the obviously parties have the right to proceed to the courts if they're unhappy with the determinations that our office makes. So within 30 days of the mailing date of an OOR final determination, any party may file a judicial appeal. And that can include, you know, direct interest participants in the appeal process as well. So you can file for local agencies, those appeals will go to the Court of Common Pleas. And for Commonwealth agencies, those will go straight to the Commonwealth Court. So those are sort of the next steps. And that also applies to enforcement actions, which can be filed arising from, you know, agencies that are not complying with the response.
All right, thanks, Dylan. Okay, so if you are going through this and you're thinking, man, these are a lot of issues, and how can you help us, Liz and Dylan? Well, I'm going to try to do my best to see if I can give you some tips and things that can help your process. And here we go. Let's see here. I'm just trying to pull up something. All right. So just to start, and we're getting a lot of questions in while I'm talking, Dylan. If there's simple ones, he may kind of answer quickly in the chat. If not, we will get to them later. The first thing is we have a lot of little persnickety rules here. 5 days, 30 calendar days. Deadlines are very black and white. The rules are such that there are no, oops, we forgot, or so-and-so is on vacation, or I was sick. It's very hard to rectify a major error in the process of the right to know law. And thus, it is so important to have someone in your agency that is fully trained and super duper responsible. And if that's a very technical term, super duper responsible in terms of how to in terms of a person who is dealing with the right to know law. So if you are that lucky person in your agency, you should feel proud you are seen as a trustworthy individual. So making sure you have someone who's in charge of the right to know process, who knows what they're doing and is on top of it. Another one, Always respond to a request. Dylan touched on this. If you don't respond to a request and you just ignore it, there may be a domino effect of consequences that could lead to having to release records because you didn't fight, you didn't respond, or having for even a fine for not responding. Another one, follow record retention rules. And I do not know the record retention rules for your individual agency, and we have no authority to quote unquote punish someone for not following record retention rules. But here's why this is important. There's two reasons. If there's a pretty critical record, maybe even one that could be controversial, and you say, oops, we deleted that. That does not look so good. That is something that will not play well with the public or with the media. So making sure you hold on to those records you should be holding on to. And on the flip side, and this is what I'm not so great on, if someone said, I would like every email Liz Wagenseller sent to someone in the General Assembly or works for the General Assembly, because I'm not so good at keeping clean inbox, I'd have to go through a lot of emails because there are a lot of like, what time should the meeting be? You know, when is this? How's Thursday? Thanks for that. What we call transitory emails that are not recording a real action that I could have deleted and followed our record retention policy, but because I am not a good, clean inbox kind of person, I would have to trudge through a lot more emails than I would have to respond to that request if I had kept a clean inbox. And if you are someone who is an inbox zero person with zero unread messages and sorts everything, I am always impressed. My husband is one of those people, and it always amazes me how well he is able to do that. So run a tight ship. Another one is being proactive. If there are records that you get a lot of requests for, you know, just put them on your website. You know, that is so simple that when someone does a request, you just give them a link and you're done. So putting things on your website that you get requests for. Here's an example. The city of Allentown recently announced a transparency hub where they kind of show here's how you do a request. Here's a bunch of data you can access. Here's some city laws you can access, sort of putting it out there. So not only does it make it easier to respond to requests, it's a great image to portray that we are transparent. Here's our hub of things to reach, to access. We don't even need to talk to me. You need to do a request. You can just put it all out there. Another one that is sort of a case-by-case scenario, but in this day and age of talking to people electronically without picking up the phone is a thing that gets forgotten, which is reach out and talk to the requester. Communicate with them. If there is an issue that comes up, just like in any part of life, sometimes it's better just to pick up the phone and chat about it, because the clarity you can gain versus emailing back and forth can be enormous. I spoke to a township manager years ago who had received a request for some financial records, and it would have taken his agency hours and hours to fulfill. The requester would have to pay some photocopying fees. So he decided to just call this woman and say, what are you really trying to get at here? And it turns out that all she wanted was how much they paid for snow plowing each of the past 3 years, 3 numbers. She just didn't speak the bureaucracy of government budgeting to describe accurately what she's trying to get. And so by picking up the phone, saved his agency many, many hours of work and her money. Now there's some people that you may know and understand they are not someone that it will be a fruitful conversation, so you don't reach out to them, but it can be something that is really helpful, and make sure you put it in writing. So in this case, the township manager would say, on April 12th, I spoke to so-and-so, and we agreed that I would provide these 3 records and that would satisfy her response, and put that in an email to the requester. Just in case there's some issue later, you have memorialized it in writing. So that is something that you can consider doing in certain situations, particularly if it's someone perhaps that you know. Another thing that may kind of go against the grain is, you know, the right to know law, all those exemptions that Dylan mentioned, internal, pre-decisional, insufficiently specific, not a record of the agency. Those aren't things saying that you are not allowed to provide them. They're saying you don't have to provide them. And sometimes it just makes sense and it makes life easier if you just give the records. So for example, we had a request once for my resume, and I was appointed to this position by former Governor Wolf. I did not apply to this position. My resume did not exist anywhere within our agency or the Commonwealth. So we could have very accurately or correctly denied act saying, this is not a record of the agency, it doesn't, because we don't have it, it doesn't exist. And so, but we thought about it. I thought about, okay, I am the executive director of the Office of the Open Records. We like openness and transparency. Knowing the background of the person in charge of the agency kind of makes sense. So we decided to go ahead and give this record, even though we didn't have to. So sometimes public interest might outweigh any interest in withholding the records. So something to consider at certain times. If someone puts something in the form of a question, you're like, maybe I could deny this, but I know exactly what they're looking for, I'm just going to give it to them. So think about that sometimes. Now we're going to go to some common questions. And these are some things that we hear a lot when I'm on the road talking to fine people like yourselves. One is, we got this request and maybe it is a public record. It clears all those hurdles. We have it, it's public, but oh my goodness, it's going to take us so long to fulfill it. And we have a small office, we're busy. What are we supposed to do? Got some good news and some bad news. Let's start with the bad news. There's nothing in the law that allows an agency to deny a request because it's too burdensome. In some states, you can charge labor fees. Pennsylvania does not currently have that. There's nothing in the law right now that has them. So you can't just deny it outright, saying this is way too much. Even though this is a public record, you know, we're not going to do this. It's too much work. However, and this is where you want to get to your solicitor involved. There is a court case that Pesci versus APSCA, which is the state university system versus the college instructor union. It was a decision, and it dealt with situations like this. Speaking very, very broadly, it provided sort of a guidance on how to do a rolling process instead of just saying, we're going to totally deny these records because we don't have time, or we're going to grant all of them, we've got to give them to you right away, and we're going to have to pull all-nighters, sort of a rolling process to get the denial or grant of records and giving the records out. So look at that court decision or have your solicitor look at that if that's something that you want to consider doing. Another thing that this has become less common, but was pretty big question a few years ago. What about if someone conceals their identity? They're permitted to file using their own name, but if they use a tool or something that makes them anonymous, it may result in the finding that their request was anonymously filed because you may have a policy. So listen back, you're allowed to have a policy that says we do not accept anonymous requests. The Office of Open Records has that policy. So if it's, you know, Jane Doe or anonymous Peter submitting a request, then we can deny it. And there is a court case that says if someone denies or if someone uses an anonymous function to hide their true identity, you may do that. But look carefully at the case mentioned there versus just automatically doing it because it's not an automatic kind of denial. I've already had this mentioned, but talking about must a requester submit their request on a form? And basically, it's kind of like the anonymous thing. You can have a policy that requires the use of a form, but it's something that you should have publicly posted. Shouldn't be coming out of the blue, and make sure you have that form on your website ready to use. And so you must, you must accept the OOR standard form. You can create your own if you want and encourage people to do this. But you can't say, you know what, you use the OOR form, but we like you to use our form. That is not something the law allows. And you also are allowed to accept non-form requests. If someone just calls up or says, hey, I'd like these records, you're allowed to take them, but you don't have to if you have that as your policy. Now we will talk about the hot topic in our world of AI. What is going on with AI in terms of the right to know law? Here's what we're seeing. we're seeing more and more use of that in a couple areas. One, in drafting the requests. Someone I guess types into Claude or Gemini, I want to get these records from my school district. How do I ask about them? And they will tell you very specifically, here's how you ask, and here's where you go. So we've heard of that and seen a little evidence of that, but in our world, what we are seeing is heavy use in the appeal process. As Dylan mentioned, when you appeal, you have to kind of say why you think you should have access to these records, why the agency is wrong. And previously we'd get maybe a sentence or two, like, I think this is something they should have, they didn't look hard enough. Now, because people are putting into AI, here is what the agency said as to why they're denying the record. What should I do? And these bots are very verbose. They don't just put a few little things here and there like, oh, you know, blah, blah, blah. It will cite court cases. It will go into legal argument detail about all of this. Like, they basically try to be an attorney. And so what we are seeing is a lot of evidence that AI is not quite ready to be an attorney. It's not replacing lawyers. There are some errors, there are hallucinations, and the biggest challenge is it's very verbose. It's a lot more to go through. Imagine going from a few sentences to, you know, several pages. So that is what we are seeing. And this is, as I mentioned, AI is something the whole world is trying to grapple with at this point. What do we do? How do we deal with it? How do we regulate it? Should we regulate it? And there is currently a Senate bill that would allow some denial of requests that use AI. There's talk of maybe other ones. So I would say just stay tuned. But I would ask, if you're willing and you're starting to see the use of AI in requests, it'd be great to, you know, shoot us an email and share that with us and let us know, because we only know what we see in the appeals. All right, so we are at what time? 47. So we have some time for questions. Dylan's been frantically trying to respond to some of the chats. Before I do that, some additional resources. If we don't get to your question, or you think like weeks or months or years from now, what did Liz and Dylan say about that? Feel free to reach out to us. You can call us or email us. We have a chock full of resources on our website. If you go to we have every decision we've made. So if you have a question about credit card statements or security footage, you can type that into our search function and seek other cases, perhaps to see what other decisions can be found. All right. So, Dylan, do we need to do some verbal kind of discussion of some of these questions? Also, this is obviously we're doing this right now, but if you are interested in the Sunshine Act, we're doing a training on that on May 19th at 10 a.m. and that will be a good one. Always lots of interesting, good questions from the world of people dealing with the Sunshine Act.
All right, so we have a couple additional questions here, and I want to see if we can provide some responses for these. Like I said, you know, our contact information is up here. You can leave us a voicemail. You can send us an email. We can do our best to provide what information we can. Of course, we can't provide legal advice or comment on specific requests, that you may want to consult your solicitor, but you can reach out to us. So there were a couple other items here that I, so the email is on there, is openrecords@pa.gov is our general email, openrecords@pa.gov. So.
All right, so folks, Scott, I know you said it's come from data mining companies. I'm not aware of legislation. There's always talk every year. I think this bill has been introduced to limit commercial requesters. Some states have strict limits on that. Some states charge fees for commercial requests. I will say this, we don't get a lot of appeals from data mining companies or commercial requesters. So we don't see a lot of appeals on that. But I don't know if they don't appeal, they just don't by habit, or if the requests are always granted.
I had a question here about AI generated requests, or just requests in general, conceivably being a vector for harassment or large numbers of requests being sent. So whether or not some requester's behavior or, indeed anybody's behavior could constitute harassment or run afoul of any other kind of protection is ultimately not a right to know law question. So the right to know law deals with, the questions of the records and things like that and the appeal process. But whether or not, a requester is violating some other rule or law is ultimately not a matter of our office's jurisdiction. So we can't really comment on that too much. We had one here about an agency requiring an ID to be submitted with the request. There's not generally a provision for that. Generally speaking, a requester has to be a U.S. resident, and there is a checkbox on our newest standard form to allow requesters to indicate that they are, a valid requester. If there is ultimately a dispute about whether or not an individual is or is not a valid requester, then that, may need to be adjudicated in the appeals process. There was a question about zoning officer notes and complaints. Unfortunately, I can't comment on specific records too much here right now. You can search our final determination databases.
Yeah, Vicky, I would just type in zoning in our database and see what comes up with.
Sure. I can't, so we have a question about a person filing an appeal because because of failure to include information about the procedure. We can't comment on specifics about their, whatever the requester wants to sort of have adjudicated in the appeal, that would ultimately be a question for the appeals officer.
Shannon, yes. Board of Commissioners, anyone can talk about the number of right to knows and the cost. That's all public information that I've seen that more and more to demonstrate to residents the costs of that. That is something to talk about. And if you are interested in changes to the law, I would share that with your state senator or state representative too. Hopewell Township, if you want to email us examples of people using AI to write them, yes, that would be great, because I am talking to stakeholders and legislators all the time about AI, and to be able to have some real examples would be great.
We have a question about police incident reports. So, again, we can't be definitive. There are exemptions that can pertain to investigative records, including both criminal and non-criminal investigative records. Like I said, you can view our final determination database for those categories. It may not, cover everything that is being implicated in a given request. So, case by case basis, but there can be exemptions that can pertain to investigative records. And real quick, we have a question. Will this presentation be available on a video for later viewing? We are planning to post a video recording of this on our office's website. And that page, our webinar page under the training tab on our website, also includes video recordings of previous presentations, like, for example, the specificity webinar I mentioned before, our recent right to know law for law enforcement agencies, and other presentations can also be found on there.
Hopewell Township can right to know requests be public? Yes, they can be. And we even in the Office of Open Records, we have every right to know request that's been made and our response, including the records, on our website. I'm not saying you do that, but that's how public they are, that they can get them. So one time someone asked for my outgoing voicemail message. So if you really want to hear that, go to our website, you can hear it. Can one person request all police records on another person? I mean, you can request what you want, but investigatory records, criminal and non-criminal in Pennsylvania, are exempt under the right to know law in perpetuity. So including, 60 years ago. So there are a lot of exemptions that may touch on that. And there are also some laws outside the right to know law. CREA, which is a big one that may make that challenging.
Sure. Yes. So one thing is sometimes, a person may have an entitlement to a record because of their personal relationship to an incident or an event or something like that. But that is, to the extent that that exists, it would be outside the scope of the right to know law request process. We have a question here. I'll just read out. If someone is requesting all records of money is given to a specific organization, what do we have to give? Budgets, copies of checks, bank statements, all. So, again, we can't comment too much on specific requests. like I said earlier in the presentation, financial records are generally public for the purposes of the right to know law. But in terms of any specific request you receive, I mean, it will be a question of, is the request sufficiently specific, and do the items that you're referring to fall under the specific verbiage of the request? Sometimes you may also be able to clarify with the requester exactly what they're looking for. But ultimately, any request has to be responded to on a case-by-case basis. You may want to consult your solicitor if you're unsure, and of course, the requester always has the right to file an appeal at our office, so we can't be too definitive about that, in terms of, anything may need to be adjudicated in the appeals process if it gets to that point.
Yes, Sarah, that is just kind of a line is, if you get a request and you are just like, what are they asking for? I don't understand. And you feel like you could defend that decision to our office if it's appealed, you may consider denying for that. But if it's a puzzle as to what they're actually asking for, then it's something that you can consider that.
So we have a question here. Is there a standard procedure to file an appeal bit that should be included in a response to a right to know law request, or do we need to come up with one of our own? So we do have a template. We have a bunch of different template letters that include certain kinds of potentially sort of starting point, baseline, boilerplate language. That is something that you can refer to. It won't necessarily be, like I said, applicable to all situations, like, for example, the law enforcement appeals, but those are on our website. And I may even be able to pull up the website here real quick, but under the right to know law tab, actually, it's a page that I previously linked, the RTKL forms page, that has some templates as well as, the forms and things like that on there that you can refer to. So I just pasted the link again in the chat. So we have a question about, due to the significant number of RTKs we received, we began posting them to our website, redacting the requester's information. Do they need to be redacted, or can they be posted as submitted? So, like we said, generally speaking, the completed standard form is generally a public record in our office. When we grant or partially grant a request, we post those generally unredacted on our website. We never want to be definitive. People can put all sorts of things on their request forms that may need to be redacted, so I don't want to say that they never should be redacted, but generally speaking, the completed form is a public record for the purposes of the act and can often be, made available. So, I mean, in general, some of the contact info can be available, but I don't want to be too definitive about all situations. And not to get too into the weeds, but certain kinds of exemptions can be very fact specific, like if there's questions about right to privacy and things like that, those can be sort of fact specific determinations. And I don't want to be too definitive about that, because, just as always, any specific issue can be subject to its own review.
Time for one more question if someone wants to type really fast. Going once. Moving twice. All right. Thank you, everyone. Really good questions. Join us in May for the Sunshine Act, if that's in your world, to encourage those in your agency to deal with that, to join us. And I hope you enjoy the rest of your day.